Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Flint, because this is a super interesting case. But before I review these facts, so that everyone understands, I want to go back a couple of weeks, or maybe it was last week time, just because we had a suit in New York with the special duty rule. And here's what happened, because we've got to revisit that before we talk about this. Again, this is just a lawsuit. It's not a decision. So it's important on what we think, what we think they're going to face here, because this is a big deal. This is public, right? So in New York, there was a fire, and the fire department responds, and the assistant chief or the chief says, homeowner, we got this. We're going to take care of it. We'll put it out. And the fire doesn't get put out, all right, timely enough, allegedly. And the court kicks out the case, dismisses the case early on because there was not a special duty. And now you're going to see, everyone will see where my mind is going to go before we talk about Flint. And what the court said is, listen, first of all, in New York and many other states under like a public duty doctrine, et cetera, you need to establish that there was a reliance, a one-on-one conduct, which resulted in reliance. I'm not doing the four perfect test, right? Summing it up so that the homeowner would have to rely on, in this case, the fire department to perform a duty, and that the fire department would have had to know that if you told someone you were going to do something and you didn't do it, there would be damages. Like, for example, don't jump, we're coming to get you, and the person doesn't jump and dies in the fire because we never got him. The reason I'm bringing that case up is because I think that is exactly these facts. And in that case, what the court said is, listen, there was no special duty because the fire was already well involved. They were just performing a duty anyway to respond to the call. That duty is owed to the public at large, not to the specific individual. So we are dismissing the case, said New York, because there's no one-on-one duty owed. Again, I'm repeating this, but it's going to be important here. The fire had already been well involved. They're responding anyway. So here, now with that background, everyone will understand my thought on this, which is we have a fire that was underway. Two boys were in the fire, and it's very interesting as you read the facts. So the allegation was the fire was mostly out, which I only got near the end. Mm-hmm. These two firefighters are assigned to do a primary search. They claimed they did a primary search. The allegation is they didn't, and it wasn't until the secondary search that the bodies were discovered. Right now, we're missing a little proximate cause, which is had they were discovered earlier after the fire was already out, right, that they could have been saved. But you don't even have to deal with proximate cause, which we'll talk about, if you look at duty. Isn't this, I ask you what your thought is, isn't this case which says, listen, had you not lied and conducted a search, right, or because you lied and conducted a search, you breached a duty? Well, yeah, but no special duty or public duty. What, right? Is this any different than saying, look, the fire was already involved. At this point, it was almost out at the time they were alleged to have not conducted or lied about conducting their search. How is there a duty at all owed one-on-one to the kids nonetheless, right? The kids didn't rely on them. The father didn't not do something, or the mother not do something. I don't see how this doesn't get dismissed immediately for no public doctrine, duty doctrine, or no special duty.
Yeah, I agree, and but I think there's a bigger issue in this case that wasn't really mentioned in the complaint. I'm a little bit surprised because I've been following this for a while now. The two firefighters shortly after this that missed the two kids on the primary search were initially suspended, and then one resigned, the other was terminated, or they both ended up resigning. Okay, in addition, the fire chief was terminated. Okay, and there was a question about competence and whether or not they actually did the search, were they trained to do the search, and all the stuff that goes along after this. There's also, my understanding is there's a racial component to this that was not in the case.
That's clearly the undertone.
You know, and that they didn't diligently, the firefighters who were white didn't diligently search. And I want to speak from my personal experience. When you're looking for a body in a primary search, we're assuming that you've had a real fire, not just a little, you know, smoke in a building, but you had a fire.
Hard to miss.
You can't find them there. Everything is the same color. Everything is the same color. You can't see it. And I sympathize with the firefighters. I sympathize with the victims as well, but I sympathize with the firefighters. I've been there. I can't say I have personally missed a body, but I can tell you I have been the incident commander where we missed bodies on the primary and we only found them on the secondary. And it's hard from an incident commander's perspective to have that happen. And it's even harder. I've watched my people really upset.
They didn't look under a bed, or they grabbed something that didn't feel like a body.
I've gone in. I went in on one in particular, it stands out in my mind, like clear as day. I don't, it was as clear as day. I think it might have been as a battalion chief. It was my first fatal fire, not my first fatal fire as a firefighter, my first being the incident commander. And they missed them on the primary. They missed them on the initial secondary, and the people were insisting that there was somebody in there. So we sent my best team in there. Actually, my brother's crew went in, and my brother found them. But he called me in, and he said, "I want you to see this." And you could not make out the person. You could not. You just couldn't see him. And then once you saw him, like there was ceiling and debris and everything over them. It was a woman and a girl, and her head, she's actually on the toilet. Her head was on the toilet, and there was ceiling and everything draped over her and everything. But my point being, this is not something that is in any way easy, and it is understandable that it happens.
If they missed it. Now here, the question is, did they actually do it?
Well, and that's apparently there was some sort of a partition in the room, and they were on the other side of a partition. But be that as it may, okay, the challenge here is you've got all this stuff, public outrage and anger, the termination of the firefighters, the termination of the fire chief, and all of that, which probably, I mean, maybe it should have happened, maybe it didn't. I can't say, okay, but you've got all of that sort of in the background, and now we have this lawsuit that's alleging that the firefighters were negligent. And I agree. I think that the public duty doctrine should prevail in this, and the case should be dismissed. But I want to go beyond that. Even if they don't have the benefit of the public duty doctrine, they should prevail on they could prevail on the negligence aspect. Okay, that they weren't negligent. They didn't breach a duty of care, because it is such a challenge. That's number one. And then the other one is you mentioned it going in here,
Causation.
Proximate cause.
Yeah.
How do you prove that if they had found him on the primary, you know, that it would have? Now, in this case, the brothers, I believe, did survive for a brief period. I'm not sure if this is the case I'm thinking of, but there was a case where the fire victims, and I think this might have been, they survived for a couple of days. Well, it might not be. It might be a different case I'm thinking of. So, but that would be one example of where you could show proximate cause if they had survived for a couple of days and expired. You say, well, an extra 10 minutes might have made a difference.
Right. And what's weird here is, though, you're kind of near the end, you say, because the fire at the Pulaski residence had already been knocked down at the time the two defendants were ordered to conduct the search of the second floor. I stopped there. I'm like, wait a minute. So if the fire was already knocked down, this is so late in the game. I suppose you could say, why didn't you conduct a primary search before? But wait a minute, telling a fire chief what is safe, what is worth it. And apparently they were told, or they should have known, the allegations made, that these people were in the house. But if fire chief gets there and says, listen, I'm not sending anybody in yet until, maybe because it's building construction or extent of involvement, whatever it was, I don't understand why, well, you wouldn't focus a lawsuit on that, right? Because it's totally a fire chief's judgment. But if the chief then waited until we're almost in knockdown overhaul mode, how are you going to prove? I mean, come on, the fire has been totally going for all that time. I just don't see how they ever would prove it. And I don't want anyone to think, because I'm always afraid of you and I being accused of anything. We're not saying that we do or don't sympathize with, I mean, we did say we would sympathize with a proper search if one were conducted, right? That it's easy to miss, but we're not saying that it's a good or bad, that we don't understand the victim's feelings, right? Or the relative's feelings, but as a legal analysis, right? Doesn't mean that something wasn't wrong, you're not winning. And, you know, this is a big deal. I don't know if there's special duty or public duty doctrine in Michigan. I have no idea,
Yeah,
but
I think there is. I think Illinois, this would be a tough case in Illinois. The Illinois Supreme Court a few years ago abolished it. So that would be one less protection that firefighters have in Illinois. But in Michigan, I believe the public duty doctrine is still in effect.
Washington State, they would probably win too, or, you know, could get past it. So.